Subscribe to both of my YouTube channels, Sharron WINBUSH and Goddess Sharron. Turn on notifications and share all videos globally. Thank you. Since this is 5 pages long, which is the smallest portion of the entire motion that Jennifer BONJEAN is filing, and it was the most controversial, I thought I would go through and read it and explain it from my vantage point. So this is the motion to have a new trial filed by Jennifer BONJEAN, February 17th, 2022. So she already previously covered the jury selection process, and then her second reasoning for wanting or requesting a new trial is based on the judge's decision at the Curcio hearing. The subject is Nicole blank Becker, but this is based on the judge's decision. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant, Robert Kelly, and the government's star witness, AZRIEL CLARY, that was imputed to the entire defense team. Defendant is entitled to a new trial where he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of trial, it was discovered that one of defendant's attorneys, Ms. Becker, may be suffering from a conflict of interest because of her prior representation of the government's key witness, AZRIEL. Consistent with its obligations, the court conducted a Curcio hearing and concluded that Ms. Becker had entered into an attorney-client relationship with AZRIEL while she was representing Robert Kelly. Although this conflict was an unwaivable conflict, that's the important word, the court, meaning the judge, permitted defendant to waive it. That's the whole premise of this. It was an unwaivable conflict that the judge permitted the defendant, Robert Kelly, to waive. That is her request for a new trial. Because defendant was denied conflict-free counsel by an attorney who likely possessed information that could have been used to discredit AZRIEL's testimony, but was unable to utilize the information without revealing attorney-client communications. What she is saying, the judge ruled in the Curcio hearing that Robert had 3 conflict-free attorneys in Farinella, in CANNIck, and in Scholar. But Nicole, which is why BONJEAN is using this particular issue, she's saying Nicole specifically had information that could have helped her client that she couldn't use without revealing attorney-client communications. So the defendant was prejudiced by this conflict. So she's saying that Nicole couldn't utilize any information she may have had concerning AZRIEL without revealing attorney-client communications. The Sixth Amendment mandates that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. U.S. Constitution Amend 6. This right to counsel includes a criminal defendant's right to be represented by the counsel of his choice. However, this qualified right is supported by, among other things, the Sixth Amendment right to effective assistance of counsel. The defendant's Sixth Amendment right to effective assistance of counsel includes the right to representation by conflict-free counsel. So what she's saying is, yes, he does have the right to be represented by the attorney of his choice, but the Sixth Amendment overrules that because he must have conflict-free counsel. Now, the judge was saying 3 of his attorneys were conflict-free. BONJEAN is arguing because Nicole had specific information that could have been beneficial to Mr. Kelly, but she couldn't utilize it because of attorney-client privilege, and she was banned from even cross-examining Azriel, that in some way made Robert have a conflict with his counsel. So he didn't have the complete representation that he would have had otherwise. A per se conflict of interest exists where the attorney was not licensed to practice law because he failed to satisfy the substantive requirements of admission to the bar, and where the attorney was implicated in the defendant's crime. The per se rule applies when an attorney is implicated in the crimes of his or her client, since, in that event, the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing. She's citing the case law, which is the United States versus Fulton. She's not saying that's the case here. She's saying that's the precedent set by case law by which she's arguing this particular part. An attorney has an actual, as opposed to potential, conflict of interest when during the course of the representation, the attorney's and defendant's interests diverge with respect to material, factual, or legal issue or to a course of action. While a defendant is generally required to demonstrate prejudice to prevail on the claim of ineffective assistance of counsel, this is not so when counsel is burdened by an actual conflict of interest. Prejudice is presumed under such circumstances. In the case at bar, defendant is entitled to a new trial where his attorney labored under a per se and or actual conflict of interest that could not be waived. BONJEAN is arguing this conflict was not waivable. She is challenging the judge on her decision to allow Robert to waive this. At the Curcio hearing held on July 15th, 2021, just weeks before the commencement of the trial, Azriel's prior attorney, Ms. Rodriguez, disclosed to the court that she was previously retained by Azriel and another possible government witness, Jay Savage, in July of 2019. Now keep in mind, Azriel and Joy were both with Robert at that time. Neither one had jobs, neither one had money. So who retained Ms. Rodriguez? Use your common sense. Rodriguez met defendant's attorney, Ms. Becker, in person at a bond hearing at the Dirksen Center, July of 2019. July of 2019, Azriel and Joy were both still with Robert. Robert had just been taken into custody. Nicole was not on any case at that time. Ms. Rodriguez expressly told Ms. Becker that she represented Azriel and Savage, instructing her not to contact Azriel. Ms. Rodriguez provided a text message to the court that showed that she, Rodriguez, texted Ms. Becker stating, "I don't want the lines blurred regarding our role, and I think they are already blurred. Please do not contact them at all without my knowledge." Rodriguez told the court that she later learned that Ms. Becker had been contacting Azriel and Joycelyn. According to Rodriguez, Azriel suggested that she was getting advice from Becker in connection to how to handle the media. Rodriguez declined to divulge further information about her conversations with Azriel, but stated that her representation formally ended when she received instruction signed by Azriel telling her to provide her attorney's file to her new attorney, Miss Becker. So Azriel told Miss Rodriguez to give her file to Miss Becker. And again, Azriel doesn't have any money, so someone was paying Rodriguez. And Miss Becker is the one Robert put in charge of paying the rent, making sure each female had money, food, whatever they needed, because he only wanted a female conducting his interactions with Azriel and Joy. So he put Miss Becker in charge of that. Miss Becker confirmed that she had communications with Azriel. The government also confirmed that Azriel had told prosecutors that she had a lengthy meeting with Miss Becker in August of 2019. The government revealed that in their conversations with Azriel, she revealed information to the government that she received from Miss Becker that the government viewed as adverse to the defendant. So Azriel is telling them, and again, Azriel is a liar at the point that she did these things. She was not a government witness. So once she became an informant January of 2020, she then told the prosecutors that she got some adverse information from blank Becker that she could use against the defendant. And she's doing whatever she can do to hurt Robert at that point. So you clearly see what's going on. After considering statements made by Ms. Rodriguez, the court noted that Ms. Rodriguez stated that Ms. Becker had given her clients legal advice that conflicted with the advice that Rodriguez had given her client. This court seemingly concluded that Ms. Becker had formed an attorney-client relationship with Azriel while she was representing Robert. This is saying because Azriel told them Nicole gave her some advice, the judge, Ann Donnelly, concluded that that meant she had an attorney-client relationship with Azriel. Evidence not only by Ms. Rodriguez's statements, but by the fact that Azriel instructed Rodriguez to send her file to Ms. Becker. So the court was concluding because she received a file that made her have an attorney-client relationship. The government further pointed out that Ms. Becker might suffer from a so-called Fulton conflict, which arises when a lawyer is accused of misconduct, whether true or not. That's what the prosecution stated. In those scenarios, the attorney may violate his or her duty of loyalty to her client by prioritizing her own interests in defending herself against the accusations of misconduct. And they cited case law of Fulton Supra. This court acknowledged that Becker did suffer from a conflict. So the judge concluded, based on whatever she heard at the Curcio, that there was a conflict, but that it amounted to a conflict that could be waived, which means based on what the judge had in front of her, she viewed it as not serious enough to remove Nicole, but sufficient enough that it could be waived. And the judge mitigated this by ensuring that Becker did not conduct cross-examination of Jane. This court afforded Robert Kelly the opportunity to consult with a third-party lawyer and admonished him before accepting his waiver of conflict-free counsel. Defendant is entitled to a new trial where his attorney, Ms. Becker, labored under a per se or actual conflict of interest that could not be waived. So her argument is the judge waived this conflict-free counsel, but by the Sixth Amendment statute, it could not be waived. First, as the government pointed out, Ms. Becker seemingly suffered from a Fulton conflict, a per se conflict where there is no question that by communicating about the case with the government's key witness, notwithstanding that the witness had her own counsel and did not consent to the communications. She opened herself up to accusations of misconduct or even possibly an attempt to influence a government witness on behalf of her client. Now, this is Jenny from the block using the government's argument against them. Pay attention. She's not saying any of this is true or not. She's saying this is what the government used in the cursio. Since the government said it in the cursio and the judge allowed it, she's saying this created the problem. So actually, basically, she took what they did and she's now turning it around and using it against them. That's good lawyering. This is not to say that the allegation is true. So she's saying the government said this. This is not to say that the allegation is true. But an attorney who may be perceived as having engaged in that type of misconduct suffers from a per se conflict, since the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing. Second, when Ms. Becker formed an attorney-client relationship with Azriel, her interests diverged from the defendant because she also owed a duty of loyalty to Azriel, the government's key witness. Ms. Becker was placed under inconsistent duties because of her representation of Robert Kelly and Azriel, an adverse witness. Prejudice must be presumed where Ms. Becker had at least one extended conversation with Azriel about her relationship with Robert and may have obtained privileged information from the file that Azriel's prior attorney sent to Becker at Azriel's request. However, Becker was prohibited by the attorney-client privilege from disclosing any information she may have received from conversations with Azriel or from her prior attorney's file, even if that information would have been beneficial to the defendant's defense. Similarly, as the government suggested, although the record is unclear on this point, Jane Azriel may have obtained privileged information from Becker that was adverse to the defendant, information that most certainly was passed along to the government. So they're not saying it happened or it didn't happen. She's saying the government interceded and brought this ambiguity into the Curcio hearing, and now, as any good lawyer should do, she's using it, Jenny from the block is using it against him. That's smart. So you look for anything that you can throw at the wall and see if it sticks. Courts have recognized that where a lawyer seeks to simultaneously represent a defendant and a cooperating witness in the same criminal proceedings, a conflict of interest exists. Further, whenever a defense attorney has previously represented an important government witness who testifies against his client, the possibility of a conflict of interest exists. With these principles in mind, Ms. Becker suffered from an actual conflict of interest that could not be waived. That conflict was imputed to her trial partners. An attorney's conflicts are ordinarily imputed to his firm based on the presumption that associated attorneys share client confidences. If Becker had merely interviewed or conversed with Azriel, she would have had no duty of loyalty to Azriel that conflicted with her duty of loyalty to Robert. But as the court concluded, she's putting it in the judge's lap. She's saying, Judge Ann Donnelly, you concluded Becker formed an attorney-client relationship with Azriel. That put her at odds with her duty of loyalty to the defendant. The risk of prejudice was made more significant by the fact that Jane was not just any witness, but the government's star witness. Defendant's Sixth Amendment guarantee of a conflict-free counsel was denied. In light of the foregoing, defendant's convictions must be vacated and a new trial ordered. So this is called good lawyering. This is what a good lawyer does. They go through all of the court papers and they look for anything, everything that they can use to get this man acquitted or to get a new trial. Since this was only 5 pages long, this was the least significant thing that Jennifer Bonjean put into these motions. But you use everything you've got. You use everything you've got. The fact that it's only 5 pages says it's the least important. The fact that it's only 5 pages tells you this is a long shot, but I'm going to shoot it anyway and see what sticks. Because it's 5 pages, all she's saying is, Judge, you're the one that said that she had entered into a client-attorney relationship with Azriel because she got a file folder. Since that's your conclusion in the Curcio hearing, since the government said she was suffering from Fulton, which meant, she couldn't perform her duties as a lawyer, then you have just given me the ammunition to trump that decision with the Sixth Amendment right. You could not waive his right to conflict-free counsel. So what I'm understanding this to mean, when they had the Curcio hearing, it clearly was not a major thing because the judge did not remove Nicole. If it were serious, the judge had the authority, she had the duty to pull Nicole off of that case. This seems like the government was reaching whatever she received in file folders from the lawyers, and of course the government had to respond to it. They were stretching to make it appear like it was very serious, but obviously it wasn't that serious, since the judge not only allowed Nicole to remain, the only stipulation she put in was you cannot cross-examine Azriel. And she also concluded he could waive his right. The judge's decision was you have the right to waive your right to being able to appeal based on ineffective counsel if you decide to keep Nicole. And now Jenny from the block is using that against them to say, no, the government said she had a Fulton situation going on. Judge, you said she had an attorney-client relationship. You said she couldn't cross-examine Azriel. And as a result, I'm saying, as his new attorney, that he was denied his Sixth Amendment right when Judge Ann Donnelly made that decision. I think that's brilliant. Now, whether the judge will G for it is another thing, but that's what you call good lawyering. She's not accusing Nicole of anything. She's using what the government stated and what the judge stated in the Curcio hearing to say, based on what the government accused and based on what the judge ruled on, you, in doing so, denied this man his Sixth Amendment right. He could not waive his right to effective counsel with Nicole because she could have had some information that could have helped him. So she's admonishing the prosecution, but more importantly, the judge's ruling on that. And that's what she's requesting a new trial based on. But obviously she feels it's a stretch because this is only 5 pages long. And everything else, I mean, the total pages were like 85 pages. So this was the smallest portion of it, but she figured, let me shoot the shot and see if it'll work. And I think that's what good lawyers do. The Mute R. Kelly campaign stopped the flow of R. Kelly's income. Sony releasing him hemorrhaged him financially. His inability to tour. He had back taxes because of poor management and accounting, that the government seized assets for that. And then he had back child support. He's been not in a position to hire the top-notch legal team necessary to get through this entire case, which is why he was compromised in the New York case. He needs all his fans, supporters, or anyone who wants to help to send money directly to him, not through a third party, because he has an upcoming Chicago case, and he must have great legal representation to defend himself to the best of his ability. Mr. Kelly is fighting a case in Chicago, and he needs all of the assistance that anyone can give from all of his fans and supporters around the world. There are 3 ways that you can get money to Mr. Kelly. 1, you can send money via Western Union. That's for $300 or less. That will get to him fast. Or you can go to the BOP.gov website and send money via credit card. Those are the fastest ways to get it to him. Or you can mail a money order to him to P.O. Box 474701, Des Moines, Iowa, 50947-0001. It will go directly to Mr. Kelly, no third party, no one in between, and he will have a record of who sent what amount, and from where it was sent. So it is your way to directly help, directly impact, to directly put your hands on R. Kelly and show him that you love him, show that his fans from around the world are supporting him, and they want to assist him in fighting for his freedom.